citizen, I wouldn't say citizen lawyer, but I would call myself a citizen servicer. A lot of us in our countries of New Zealand, Australia, England, Scotland and Ireland don't realise that we were born to serve. And how are we born to serve is that when we vote the parliament in, I'll just put my chair up a bit. When we vote the parliament in, the parliament is supposed to look at what's going on with the public, and then if people are doing things wrong, they serve notice to the police, and then the police will go to the court will give a warrant, and they will give service papers to the police, and the police will serve those papers on you, and then you are summoned to the court. But what a lot of people don't know is that in private prosecutions, when your government has gone rogue and you want to get your government back in check, if they're making laws and things that look out of sync to you, you are permitted to, through your 1688 Bill of Rights, to go directly to the court yourself. You go straight, you don't go to the administrative court for a start. You go directly to the High Court and you file a submission, and then calling the ministers in, and they will issue you service papers, and then you serve to them. Now, I have done that, and I've been in the court for almost 2 years now, and the whole case has elevated into a huge case, and a lot of it's coming to fruition now, and I want to be showing you how almost everything that was in my court case has actually been brought to Parliament, and it's being dealt with right now as we speak. Now, I haven't won in the court because we got caught up in the courts doing some other things, fighting over fees and things, but everything that I put in my original submissions has come to be. Now, one of the things, I'll just start with the first thing the original statement of claim. So here is my original statement of claim, and then I use you go in but using this law here, the Declaratory Judgments Act 1908. So you can go in using two laws, all right? So the first law is your 1688 Bill of Rights under the King. It's called Bill of Rights 1688. This is not these human rights or any of these other kinds of rights. So you can use this, and then under this you've got the right, where are we? The right to petition, and that is the right of the subjects to petition the King, and all commitments and prosecutions for such petitioning are illegal. Now, the court have tried to make me pay for this, but so I'm still battling in the courts as we speak that I shouldn't have to pay, that it's supposed to be free. But that's another story. Now, this is called the Declaratory Judgments Act of 1908. And what it says here, now this is in UK, the United Kingdom has got a Declaratory Judgment Act. The Australia has got a Declaratory Judgment Act. New Zealand's got it. To my understanding, Canada has got it. To my understanding, America, some of them, you can use it if you want to, but they don't tend to use it because they use some other laws. So America's got some different things, but you can use it. So it says here, where any person has done or desires to do any act, the validity, legality, or effect of which depends on the construction or validity of any statute, any regulation made by a Governor General and Council under statutory authority, or any bylaw made by a local authority, or any deed, will, document of title, or any agreement made or evidenced by, in writing or memorandum or articles of any company, body, corporate, any instrument prescribing the powers, or any company or any body, corporate, where any person claims to have acquired any right under any such statute, regulation, bylaw, deed, will, document of title, agreement, memorandum, article, or instrument, or any manner, just only interested. So you only have to be interested in this law to file into the court and get your service papers from the court and call the people into the court. It says here, such person may apply at High Court. So you bypass administrative court, you bypass criminal court, you bypass all of the tribunals, and you go directly to the High Court by originating summons for a declaratory order, determining any question as to the construction or validity of such statute, regulation, bylaw, deed, will, document of title, agreement, memorandum, articles, instrument, or any part thereof. So you can use these two documents, the right to petition, right? And that also comes under the subject's liberties to be allowed, and you may ask for a declaration of right. And so you use these, and that what it says here in section 2 is that no action or proceeding in the High Court shall be open to any objection on the grounds that merely a declaratory judgment order is sought. So all you're asking for is a binding declaration of right. And there doesn't even need to be anything wrong. You can only just question why the Parliament are making these laws and if it's correct or not. And there will be an investigation, which is currently being carried out right now. Now, Judith Colins has come in and she said that, I'll let you listen to her in a minute, but I'll just read it from myself. She has said that secondary legislation is being drafted by ministries and councils themselves, that they are being drafted by people with no expertise in the ministry to draft laws clearly. So you're going to come, because in the 1688 Bill of Rights, this comes under unqualified persons, whereas this is why the king was thrown out, whereas divers are bringing an unqualified person to draft laws that they don't have the expertise. And this is why there's so much trouble in our countries, because the ministries themselves have been drafting the laws. What Judith says in regards to the COVID-19 response, on the 23rd of November 2021, they drafted a COVID Health Response Act, and it passed the first, second, and third readings on the same day. That royal assent, now, royal assent was given after 2 days. There was it never went to any select committee. It never went to any regulatory body for a review by lawyers and parliamentary drafters and law drafters. None of that happened. The Attorney General at least said that it should go to a select committee, but the Parliament bypassed that and did not send it to a select committee. And she said that the drafting of the law referred to terms that are unknown at law, and it should have gone to a parliamentary drafting committee. Now, I filed my case on, the original case was filed on, in December of 2022. I originally filed my case, and it got rejected once because I did not have the Maori writing at the top of it, which was illegal for a start. It got rejected a second time because I did not have a cover page, and it got rejected a third time only because I did not have the signature. They sent me for the signatures, and my case was finally accepted on the 5th of February 2022. Now, the original filing was I'll just put Judith over here for a minute. The original filing was a very simple document. So there you go, Catherine Sixtus, that's me, under the Declaratory Judgments Act of 1908. I called in Jacinda Ardern, Chris Farfoy, Andrew Little, and Ashley Bloomfield. There was no accusation. You don't need to accuse them of any crime, and in fact, they haven't committed any crime. You're only asking them to come in and ask them why they've made these laws and if it was lawful. So I simply said, to whom it has pleased Almighty God to make the glorious instrument, I, Catherine, do solemnly and sincerely, in the presence of God, profess, testify, and declare that I am a faithful Protestant, and that I will, according to the true intent of the enactments which secure the Protestant success to the throne of my realm, uphold and maintain the said enactments to the best of my powers according to the law. Now, I do solemnly and sincerely in the presence of God. Oh, this was my friend that came in with me, but she ended up going out. So we claim that an existing right shall not be held to be abrogated or restricted and deemed and taken to be, and we do pray. Now, this is a prayer that you're putting in. In the olden times, they used to put in prayers. When you put this in, you come under the protections of Almighty God. All the churches can use it. All the religions can do it. The church's job is to serve. The church is supposed to watch the parliament, and then when they see that the parliament are making laws repugnant to Almighty God, the church and their members are supposed to go into the High Court under Almighty God, and this is how you pray. This is how God said that you would pray. You enter the court of the hewn stone and you make the prayer. And so I said, I do pray that the subjects of liberties. Now, before you were named on the earthly realm, you were a subject under Almighty God, that you were not given a name, you were not given a birth certificate, and you were simply an existing being. And that just meant that you were a subject. Everything is a subject before it is named, if you know about grammar. So do pray that it may be declared and enacted that all and singular the rights and liberties asserted and claimed in the said declaration are true, ancient, and indubitable rights and liberties of the people of this kingdom, and so shall be esteemed, allowed, adjudged, deemed, and taken to be, and that all and the particulars aforesaid shall be firmly and strictly held and observed as they are expressed in the said declaration, and all officers and ministers whatsoever shall serve their majesties and their successors according to the same in all times to come. So then we put down what our orders were that we sought. We sought a declaration to the effect stating the applicant's rights without ordering any specific action pursuant to Section 2 of the Declaratory Judgments Act. So we said, we're not asking for any, they said we're not asking for any particular right here. What we're asking for is just for a declaration to say that these rights continue to exist and that they are being upheld by the Parliament, all right? So the court then asked me to put in a memorandum. Now, in the meantime, I'm going to put up, now the memorandum comes up here, and at the end of the memorandum, I'll just go a little bit to the end, but I'll read it all to you later. But what I had asked in the memorandum, that I'll put on Judith Colins in a minute, but in the memorandum, I had specifically said that Jacinda Ardern has placed unqualified ministers, most of whom are not born to New Zealand, and they are neglecting to pay due diligence to the oath to make effectual provisions to protect the nation of New Zealand. all right? And then I had asked, ultimately, down here, that we did pray for a letter to the Governor-General requesting an urgent temporary suspension of all changes to constitutional law, immigration policy, and bills and acts by ministers that are not born to New Zealand nor allegiant to the oath that they swore. Now, I'm going to read this in its entirety soon, so you're not going to have to listen to it if you don't want to, or you can listen. But I am going to ask you to listen to Judith Colins, okay? And I'll come back. Now, what she's basically saying in here is exactly what is in my case. Is what I said is that these ministers, now Chris Farfoy was a media, geez, I hope I've got the right sound here. Chris Farfoy was a media, I don't really know what he did. He was the press officer or something down at the Parliament. And he, to my knowledge, he does not have any degree in law. He has absolutely no background of any law whatsoever. It basically comes down to that he was an unqualified minister. Now, New Zealand is currently backtracking all of their laws to 1991 because what they have been doing is allowing the ministers and the ministries to draft their own laws. And Lord only knows why, how our Governor-General is allowing these laws to pass into royal assent. They're going to royal assent after never even being looked at by a qualified lawyer. Now, the Human Rights Commission, to my knowledge, is drafting its own laws in the Human Rights Ministry, and then none of them have law degrees. Now, Chris Farfoy elevated himself from a media person, a person that was involved and not even a qualified journalist at that. He somehow elevated himself to be the Minister of Justice. And then there were other ministers, our Peter Williams CO, who was a priest, he was a bishop in a church, somehow managed to get him self-placed as the Minister of Courts. The Minister of Courts, who has no knowledge in law whatsoever, who was a bishop priest, who stood down probably about a year before he entered Parliament. He stood down from his position of being a priest, to my knowledge, the Mormon Church, or the Latter-day Saints as now it's called, and Chris Farfoy became a Minister of Justice. Now, both of them took those positions, and now it gets even worse. It's come to the light from Judith Colins that those ministers were drafting laws by themselves, passing it in 1, 2, 3 days, sending it up to royal assent, and the Governor-General herself was signing them off, and they were being passed into law. So let's listen to Judith Colins, what she has to say.
The problem is, and I'm sure that members, when they wish to read the report, will understand, is that if the legislation, secondary legislation is being...
So this is all being done under a thing called secondary legislation. What has happened now, this is over in England, this is over in Australia, we're all connected. What has happened is they were not able to get around the strict laws that the King handed Parliament. The Parliament was handed the ownership or the governorship or the sovereignty of Parliament was handed over by the King, right? But it was handed over under strict rules that Parliament would be bound by the same laws that the King, the Prince and Princess of Orange were bound for. And so that was passed over to the Parliament. Now, what has happened is that Parliament have not been able to get around these laws to carry out all their dirty, rotten deeds. So what they did was they brought in this slippery secondary legislation where they thought that they could get around, and it's all gone pear-shaped. It's all just gone downhill. And so it's coming to the light through, you can thank Kate Floss for all this, to be honest. So there's obviously been an investigation over when I had called in the King. So Judith Colins is in fact a lawyer, and Winston Peters is in fact a lawyer. So they both have law degrees and they both know exactly what they're talking about. So she's come in to investigate this. So that's the secondary legislation that she's talking about.
And I'm sure that members, when they wish to read the report, will understand is that if the legislation, secondary legislation, is being drafted by ministries themselves rather than Parliamentary Council Office, there is often not the expertise in a ministry to be able to draft clearly and within the rules that are expected of legal drafting. And that was really clear. It was also clear that things seemed to not get better but worse as matters went on. When I think to the criticism of the COVID-19 Response Vaccination Legislation Act, which was actually introduced on the 23rd of November 2021 and had its first, second and third readings on the same day, that bill received royal assent 2 days later on the 25th of November, and that was actually really almost 2 years after the full first brunt of the pandemic had hit us. That bill did not go to a select committee. It did not go to regulations review. It was not given the sort of scrutiny that people should expect. And I think it would be wrong to say that there was urgency. It was very unfortunate that this happened. When we look at the commonly known as the traffic light system that was introduced, it could have taken another week or 2 or 3 or even.
So she just goes on to say that they could have taken some time and there was no reason. It was the end of COVID, but that's not really what the issue here. The COVID is just nothing now. What the issue here is that ministers who are unqualified in law, unqualified to their position, are drafting laws when it's supposed to go. They have an office, and I've just recently looked it up, called the Parliamentary Drafting Committee. And whenever a law, if the ministers are allowed to draft it themselves, and then they're supposed to send it to the Parliamentary Drafting Committee, and then they scrutinise every single inch of that act that has been done, and then they make it all legally correct so that it doesn't hurt people. And then part of my case was that they were psychologically waterboarding people with the law. Now, Judith Colins has come in and she has said exactly what my case was about. Now, I'm going to show you a clear example of this. Now, once the case got into the court, they then ask you, if they don't really quite understand what your case is about, you can put in a small case and then they will ask you for memorandums, and you can put in as many memorandums as you like. Now, the memorandums and then the opposition, so in the preliminaries, before it actually goes to the court, there are often exchanges of several memorandums, and you can add things into your memorandums that might not have been in the original case. The way that this happens is that you file your service papers, you send it to the ministers, and then the ministers will give you a response in the way of either they will completely rebut it to the court, or they will do it by way of a memorandum, and then you are permitted to feed off of that and then write your own memorandum okay? And that's exactly how I ended up with all these memorandums. So if we listen to what Judith Colins said, now I'm just going to go ahead and read this. Now, some of you don't want to listen to all this stuff, so you can check out, and I will put up in the links Judith Colins, but I will say to you that I have a lot of members who can't read, and so I like to read this for them. So this was the memorandum. They wanted me to put all of the laws, so I put all of the laws, every single law that I was going to be using in the court. I had put it in here in this memorandum, so it was clear that everybody could see what I was going to be using. So we had the New Zealand Bill of Rights Act, which England has got the English 1990 Bill of Rights. There's many rights, but none of them can hold a candle. None of them hold the ability to be able to serve papers on ministers and order them into the court. So these are all just supplements. And so what they've been using in this secondary law is acting as a pretended title of the Crown, that it's got the same powers, when in fact it really, really does not. So I've used the New Zealand Bill of Rights Act, slash it out, Human Rights Act, slash it out. All these COVID laws came in through the arse end, through the asshole of these two laws here. The International Covenant of Civil and Political Rights and the Declaration of Indigenous Rights, Universal Declaration of Human Rights, the Human Rights Commission, and then the COVID-19 public health response. These are all tied up in here. And then S28 gives us, and unfortunately, for some reason, I did not put up there the 1688 Bill of, oh yes, I have. Then under these all here come under laws, the top bits from New Zealand Bill of Rights down to COVID-19 are laws that they can change at will. And then it comes to our constitutional laws. S28 of the 1990s says all of our existing rights do not come under, not say don't come under, they are above all of these laws. I should have put this at the top. This is the Bill of Rights, 1688, Will and Mary. The Treaty of Waitangi, and I've not put up there the Declaratory Judgments Act, but I don't need to because it's up here in the original application. So that's not up there. These are just all the laws that I'm going to be talking about. But I came in on this plane. I call it the plane. This is the plane that I flew in on. And then you have to see where the plane's going to land, all right? So this is the plane that I flew in on. And it is in fact the only plane that you can fly in on. All these other ones you have to go to the lower courts. Now I said I am petitioning the court to intervene in the New Zealand Parliament for ruling arbitrarily against the people of New Zealand since 1986, when the 1852 Constitution was removed without referendum. The New Zealand public no longer have faith in the elections, as all parties have failed to hold any parliament accountable. And Judith Colins has just said it right there. Not only have all the parties failed to hold anybody accountable to the arbitrary laws, our own Governor-General is assenting arbitrary laws. So it's a complete breakdown of what we had, nor defended the indubitable right of the people. Our own Governor-General, who are just picking off the street with no legal background, have been ascending these laws without any scrutiny, without any requirement that it goes to the laws, the Parliamentary Law Drafting Committee. The Governor-General is just sailing them through on some kind of a plane. The New Zealand people are being forced to function under multiple legal systems of which they are currently overwhelmed and distraught, such as hundreds of new subordinate laws in New Zealand, thousands of United Nations laws domestically, omnibus laws. I've done a video on omnibus laws, but anyway, it's just like dozens and dozens of laws all clumped together in one bill and passed in one day, and tribunal and so on. I don't really need to do this, but I said several petitions to remove our indubitable rights, which is our 1688 laws under the King, by our own parliamentarians and politicians who are not born. They're not even born to New Zealand, or they're first generation people to New Zealand, United Kingdom and Australia. They have no law degrees and they're not practiced in law, and they're drafting laws, and it's just being sailed on through by our Governor-Generals. It's shocking. The laws change daily at the flick of a pen, the epitome of arbitrary power, causing public inability to function in their daily lives. We do pray that for the court to assert by declaration an unquestionable and certainty of law of indubitable rights remains firm amongst the chaos of the broken New Zealand legal farce. You can apply this to the United Kingdom. We put in a special thing for our native chiefs, Tamati Wakanene, Wheat Te Hikaru, and Wheat Parata, and other chiefs. These were the chiefs that signed up with all of our kings, and I've added them to the court. I've said amongst several other things, but we don't know it all. Each law must be a man unto itself, and they are ultra-vires. The government is overstepping its powers, especially when they're drafting their ministers who are not lawyers, who are not qualified to their position, are drafting laws and are sending it for royal assent without sending it to the legal drafting committee that is right next door to the Parliament, where they're supposed to send all of their laws. By using the Bill of Rights or the rights of they're using the Bill of Rights 1990 or the fundamental right as a piggybacked law onto our 1688. So they're getting our 1688, they're using this word Bill of Rights, they're not putting on it 1688, they're not putting on it 1990, so they only just put Bill of Rights, right? And then underneath that, they piggyback on all these dozens of laws using Bill of Rights 1990. And this is how they are arbitrary. It really is. It's a pretended title of the Crown. It clearly is. And they're sending it to the Governor-General, who is just signing it all off. There's nothing wrong with our legal system. Our legal system is fine. Our Parliament is fine. What is wrong is that they are not obeying the laws within the Parliament themselves, and Judith Colins has just announced it. Thank you, Judith Colins. The Ardern administration have a duty by oath to make effectual provision for the protection of our settlement. But Chris Farfoy is neglecting to control immigration responsibly, therefore endangering the New Zealand people by outpopulating them, contrary to the promise to the ancient chiefs. The New Zealand government deceived the New Zealand people into believing that the 1990 Bill of Rights is a constitutional law by lying by omission of the fact that it is an ordinary law, and it can be overridden. It's just been ruled by the courts. It can be overridden at any time. All citizens of Commonwealth countries with Queen, I should have put Her Majesty, with Her Majesty the Queen as head of state, are protected by the supremacy law. The combination of the 1990 Bill of Rights, the Health Act, the Human Rights Act, the International Covenant on Civil and Political Rights, the Indigenous Rights, the Universal Declarations, the Human Rights, the Declaration of Inconsistency, mass immigration with no controls, all contain laws that are inconsistent and repugnant to the 1688 Supreme Protections to the New Zealand people and the United Kingdom people and the Australian people and all the people in the Commonwealth. Chris Farfoy, Jacinda Ardern, Chris Farfoy, Ashley Bloomfield, Chris Hipkins have not paid due diligence to their oath of office when administering the law. And they haven't, because when they were administering the law, they don't actually need to be that qualified. But since they are unqualified, what they're supposed to do, they've got a parliamentary drafting committee, they've got a whole building stacked full of lawyers that they're supposed to send their bills to, and those drafting committees will check all of this before it's passed into legislation as a safety check. It's supposed to go there before it ascends, and they have not been doing that, and that's called negligence. That's called not paying due diligence. And that, I don't know what the laws are, but they should not be doing that. So they should not. And, they're all guilty. So the action of working towards a transfer, they were trying to make New Zealand, to bind New Zealand to any international instrument. We said that is ultra vires, meaning it's overstepping. This includes the WHO, all the United Nations. They said that they intend to make New Zealand bound to any international instrument. And so we've already got this in the court. So it's already there. So you can thank Kate Floss for that. We say that it is unconstitutional and treasonous to the oath of office to the Majesty and historical founding documents of New Zealand and the UK and Australia, including, never mind that's a bit to do with New Zealand. Jacinda Ardern has placed unqualified ministers, most of whom are not born to New Zealand, neglecting to pay due diligence to the oath to make effectual provisions to protect the nation of New Zealand, such as Chris Farfoy, who is not qualified, has not 1 ounce of legal background as Minister of Justice. He was made Minister of Justice. Now, Chris Farfoy is born in Tonga, all right? So why would you put a foreigner who came into New Zealand by either legally or not legally? I believe that his parents, I don't want to say, they may well have been legal or they may well have been not legal. But Chris Farfoy is birthed of two full-blooded Tongan parents. Two full-blooded Tongan parents. And they made him Minister of Immigration. Well, that's the fox in the hen house. William Co is a full-blooded Samoan born, so in fact he is a Mātai chief, almost a king over in Samoa, and he was a bishop in the church. And he was made the Associate Minister of Justice and the Minister of Courts. So we had two foreign nationals who had not 1 iota of knowledge in law, in legal drafting, and they were both, according to, well, they may not have been, but I only know of the COVID health response, is that ministers in their ministries were drafting laws, passing laws, without sending them to the Parliamentary Drafting Committee, and then they were sending them to the Governor-General and then enforcing those laws on the people of our countries. Now, this is, I believe, what's been going on over in Scotland with your Muslim leader, who is supposed to be Protestant, over in England with your Hindu leader who is supposed to be Protestant. And it may be happening, but I'm just speaking for New Zealand. So the Ardern Parliament has allowed these people are unqualified to their position. What does this mean? I'm not saying that they signed any laws or they didn't sign any laws. What I'm saying is that any law that they did sign that never went, and now I don't care if it went for amendments, they were drafting the law, they were enforcing it on the public, and then once the public started complaining, at that time they were sending it, to my understanding, over to the parliamentary drafting committee, who were then amending it and removing all the laws that were repugnant. And this is just it's unacceptable. The video's getting a bit long, but that my videos are. So any law that they signed to that was ascended previous to it going to the drafting committee, all those laws are absolutely null and void, in my opinion, and I'm not even a lawyer, but in my opinion, they're null and void. Now, I'm going to show you something in a minute. The Ardern government has placed a disproportionate number of foreign people with no ancestral ties to New Zealand nor allegiance to New Zealand that work only in favour of their own people and have ignored the will, which is the 1688 Bill of Rights, of the New Zealand nationals, all ignoring the subject status of New Zealand nationals and ignoring their oath of office. They are swearing their oath of office in other languages. They're not even swearing the oath in their own language, so we don't even know what they're saying. They are refusing to oath to the Queen. They're refusing to oath to the 1688. Is my video still on? Yes, I hope it is. And the Ardern Parliament has allowed several political parties to enter that are grossly repugnant to the oath of office under the majesty and duty to the people to uphold their protections of the supreme law. Ultimately, now I'm not going to read all of this, but we've said that. I will read it. Ultimately, we do pray for a declaration that all United Nations non-binding law, all human rights law, all declarations, all international laws are accountable and subordinate to New Zealand domestic law, with the Majesty as head of state, all Health Acts, all New Zealand ordinary laws, the New Zealand Bill of Rights, all pre-existing rights that have been attached, all acts of the Waitangi Tribunal are accountable. We're asking that they all be held accountable to the supreme law of the Bill of Rights 1688. Now, that has actually happened. So that's come out in another act, which I've actually done before. I'll post it up for you. I have done a video on that, and you can thank Kate Floss for that. That has already happened, and we've managed to get a law passed by an act, but unfortunately the act only says until 2025. So until 2025, there has been a proper enactment that has properly ascended, that has said that the supreme law of the 1688 Bill of Rights will overpower any other law, every single law. So we've got it placed up at top at least until 2025. So I don't know what they're going to do in 2025, but I will post up the link for that. You can thank Kate Floss and the Oreo team for that. Under the protection of the present Majesty, at this time, Her Majesty Queen Elizabeth was still alive. By divine intervention, Her Majesty passed midway through the court case, and we were able to ascend the King, who is sitting in the Supreme Court at this moment as we speak. And a successor is already proclamated to His Majesty. She had already proclamated to His Royal Highness Prince Charles and future Queen Camilla, and we've said in all attempts to remove or supersede the supreme law are under God are illegal and void. We do pray for a letter to the Governor General requesting an urgent temporary suspension of all changes to constitutional law, all immigration policy and bills and acts by ministers that are not born to New Zealand nor allegiant to the oath that they swore. The New Zealand public pray for some time to scrutinise. So we've only asked for a suspension for a period of time, and that has already been ordered in the first 100 days of Parliament as we speak. The New Zealand public pray for some time to scrutinise through the courts an investigation into the actions of many foreign nationals in New Zealand Parliament that seem to be functioning against the best interests of the New Zealand public and against the constitutional agreements set by the ancient Aboriginals, and this was set by the ancient Irish and the ancient Scottish and the ancient English people, but this is of New Zealand, and Her Majesty Victoria, Queen of the United Kingdom of Great Britain and Ireland, on the 14th day of January 1840 and the 26th day of September 1865, also including an investigation into New Zealand National's function pursuant to the consistency of safety and welfare of this Protestant kingdom, and the premises that all ministers' officers are bound to draft. Oh my gosh, and she's talking about all the ministers are bound to draft laws according to the oath, and supremacy in their office is required by law. Strict scrutiny must be conducted to affirm that all ministers and officers are deemed to be functioning within the boundaries preserved to the people by William and Mary and their successors. Thank you, Judith Colins. I think I'm just going to go back and listen to what she says. So she's talking about the drafting of laws, and it's just clear that they have been reading Kate Floss since the very beginning. So have a listen.
Problem is, and I'm sure that members, when they wish to read the report, will understand, is that if the secondary legislation is being drafted by ministries themselves rather than parliamentary council office, there is often not the expertise in a ministry to be able to draft clearly.
Now I'm going to listen to that in slow motion. Slow motion, or go back and listen again to hear what she says.
Is that if the secondary legislation is being drafted by ministries themselves rather than parliamentary council office, there is often not the expertise in a ministry to be able to draft clearly and within the rules that are expected of legal drafting. And that was really clear.
And that's what she says. She says they are not drafting the laws correctly according to the oath. They're allowed to draft the laws that they want because they're the parliament of the people. And so they can draft them. They can have their office staff draft them, but they're supposed to send them to the legal arm, which is their arms of the defence of the people. You can see in the 1688 Bill of Rights the legal arm of defence, and then they will check it, and this has all not been happening. So when I went into the court, there were that was the original petition to the court. I had made this short petition, then they'd asked me for a memorandum, which, as you see, I must put in there, don't save. So there was a memorandum put in there, but one of the things, this was a sneaky thing that they had been doing, and this came under the opposition filed a case, right, where am I on 20? So the opposition filed a case, so we were allowed to make a memorandum in response. So this is a response to Peter Gunn and Rebecca she was lovely, Minamin, it's very hard to say, and Peter Gunn. So we were able to give a response, and part of the response was that this drafting here was done together with the Orono team. They put in their submission of a memorandum on the Friday at 5 minutes to 5. They put it in. And we sat up all night, Friday night, Saturday night, and Sunday night, and we had to be at court on Monday morning at 9 o'clock. And we had to have this in for Cook J. And so we sat up all night and we drafted it. We were up all night and I hadn't even had time to have coffee. And I got into the court by video. I got into the court late, and then the judge said, Justice Cook tapped it. He said, don't worry, I've got it. I've seen it. I've read it. I know what's here. And he said, it's okay. And I sat there and I had a cup of coffee while the other cases were being all put out of the courtroom. And then we were allowed, but we only got 15 minutes and that's been fought still. But anyway, what I had said was, this is what they've been doing. That these were 3 cases where they've come up with a sneaky little thing to do in Parliament. What they're doing is that they are drafting a law. They are ascending the law without it going to the parliamentary legal department, and they're just only ministers that have got they're unqualified to their position. They're drafting it. They're ascending it on a plane to the Governor-General, and she's just passing it. And then what is happening is takes the people a few weeks to read these laws and to understand what these laws mean. By the time they get it into the court, it can take up to a month or 2. And then once it enters the court, after all of the coming backwards and forwards and the service papers, there's 25 days for you to send your service papers, and then there's 25 days for them to respond. Well, there's 2 months of laws that you have to sit under before it can actually get to the court. And then even when it gets to the court, they are allowing it to go through the court, which can take anywhere from 2 to 3 to 4 months, while this law is being ordered on the people, enforced on the people. And then just before the judge makes the ruling, they send it to the legal drafting department, and they either repeal the law or they have the law amended. And so they know, these ministers know, it's a manipulation of the law. They know that they've got 1 or 2 months, at least 2 months, maybe 3 months, maybe 5 months, that they're going to enforce all of these laws on you before you can do anything about it. Now, this has got to be absolutely illegal. Now, they did this, and I gave 3 examples. Grounded Kiwi Group submitted on the 15th of February 2022. Now, these little sneaky buggers read my case. My case got thrown out, and they went in and used all my laws. And I've got proof of that, but never mind. They put in their case on the 15th of February. Now, remember, the COVID response was done in November. My case went in on December. Mine got rejected a couple of times because there were papers not correctly done, right? And then these ones here, Grounded Kiwi Group, put theirs in on the 15th of February. And so they had November, December, January, and then they had February, and then it was in the court, and it got ruled on. Can't remember the exact date that it was ruled on. But anyway, on the 27th of April, about a week before the case was ruled on, the four respondents, Jacinda Ardern and the other ministers, changed the law before the case was heard in the court. And so they ended up reading 400 pages only to be told that the law had been changed and it was now irrelevant and obsolete. The same thing happened. NZSOS put in a law on the 7th of March, and the law got changed on the 23rd of March before the 8th of April ruling, rendering the case useless and a waste of the taxpayers' money. So another one was Ryan Yardley versus Minister of Workplace, was placed in on the 15th of February, and the case was heard on the 25th of February, and then the laws were also changed for that one before the case could be heard in a court of law. So what they have learned nowadays, is that all they do, minister writes the law, passes it within 3 days, without sending it to a select committee, without sending it to the legal drafting committee, parliamentary drafting committee, all the lawyers, all the solicitors. They are sending it, piggybacked on, it's a pretended title of the Crown, piggybacked on to the 1688 Bill of Rights to the Governor-General. The Governor-General is signing off on it. Then it's coming back down, and then what they're doing, after it's been ascended, they're sending it over to the legal department to add all sorts of amendments, and then they're reproducing the law. They are manipulating the law. This is a huge, never mind the COVID, this is a huge, huge thing that needs to be investigated, but you'll be hearing from me more. Now, I want you to go and watch this man here, who's a very clever man. I'll post him to the links. He's done an open letter to the King, so he's gone directly to the King. Now, I think he's a little bit off, but he's also a lot on. So go and listen to this guy if you want to stay up. My channel is not for babies. My channel is for serious, serious people that really want to understand what's going on and make a difference. So you've got to be able to read. For those that can't read, you can listen to my channel. Now, my case is currently still in the court as we speak. I always do all my laws up the top, but then I add in my little bit of flavour. Now, these are all the judges there's me, Kate Floss, and that's the French weights. If you remember that it was the French that were ruling over all of England, and that England ended up having to bring in their own king, an English king. Well, they brought in a German king who they're trying to, through bloodlines, make them into British kings. Now, so I put on, this is the French with their 100 pounds of weight. These are all the judges that have come to see me in the court. And then these are the two registrars that have tried to make me pay. And it's these people that I'm battling. This is a whole another story. But these are all the judges, and there's all the way. So I'm still in the court, even though we've made a lot of progress. Just through that one application, it has evolved into a great big heavenly battle with Kate Floss and the Oreo team. So here was my 23rd of May 2022. I submitted on the 22nd of February after being rejected. I was rejected 3 times. I went back, finally got in, and then The ruling was on the 23rd of May 2022. While all those other cases were going through, my case was in the court already. And then from there, they struck me out. I went to the appeals court over here. Appeals court tried to make me pay. I went to the Court of Appeal against the appeals court registrars, and then from there, both of these ascended to the Supreme Court, where I applied for another fee waiver, and then that got turned down, and then that went to the Supreme Court. Now, she threw me out, and then this case here with Judge Brown then went down here, and then there should be a line here. This actually, well, it went to here, then over to here. This case here went over to the Supreme Court, which I had to pay $1,000 fee, and they mooted me. And so that moot ended up, because they said I was out of time, so that moot ended up back in the Court of Appeal, where I lost my out of time case. And so then that went to the court, that was with Justice Goddard, then that went to the Court of Appeal, and then that went over to the secondary, another from the same Peter Greenhow. This is the 28th of November 2023, and that is waiting for a Supreme Court ruling in 2024. Now that we've been to all of these places, there's an empty space here, and that is going to be able to go to, the European Court, because we are all protected under this European Court, but you have to go through all your own first, because they've said that you have the right of access to the court. Now, I know over in England, they're blocking access to the courts, and I'm saying to you that you need to enter the court and go directly to the High Court and start serving them, and then you will go on an incredible journey, as I have, and it's all done through, England has got it, the Declaratory Judgments Act, where any person, such person may apply to the High Court by an originating summons for a declaratory order determining any question of the construction of any law. All right, now I can say to you, Richard Vobes, who's really clever and getting very interested in the laws, he's done talking to all these common law people. He's a doer. This man is a doer, and he's saying, right, we're going to do something here. Now, I will show you that the Declaratory Judgments Act 1908, UK, and then you'll see that it actually should come up in the United Kingdom. Hang on. I have had it before. It's over in Australia. They have it. You can go and look over there. Declaratory judgments in New South Wales. Here. That's the civil procedure. There should be also a Declaratory Judgments Act. Is it down there? You can go and have a look for it. I'll put United Kingdom. You might have to fish around a bit for yours over in the United Kingdom, but I have seen it. I can't find it right now, but I have seen it. So you'll be able to go and fish around it there. Anyway, so that's it today from Kate Floss. Thank you very much for coming to visit me. It's a bit of a long video, but you can watch it in sections. and I'll see you later. Thank you. Kate Floss, fighting for the Commonwealth and fighting for the King. Fighting to hold the parliamentarians to account and also the King to account. I think the King has lost we need to bring him back to his rightful path. He was supposed to have power over the Dominions. He was supposed to have power over all of this. When the Parliament went rogue, we were supposed to be able to apply for the King. And that's what we need to do. We need to start using all of the things that we've got available to us, Kate Floss.